How is confidentiality handled within third-party reproductive agreements? So obviously privacy is a huge concern for the parties involved, not just for the parents, but also for the surrogate or a donor involved. There are some arrangements where the parties want to share it with the world and blog about it and share it on social media, which can be a wonderful thing. But there are also many parties, surrogates and parents and everyone involved that want to keep the whole process very private, and they have every right within their power to do so. So when entering into any kind of reproductive matter, it's important to kind of make sure the parties see eye to eye on what they kind of anticipate confidentiality to be like within their arrangement. So for example, if the surrogate wants to have a blog and share everything on social media, you have to make sure she's matched and working with intended parents who would be okay with that, whether or not identifying information is shared or not. Sometimes people just want to keep it as private as possible. So with all that being said, within the applicable contract, so this could be within a surrogacy agreement or within a genetic material contract like donation of egg, sperm, or embryo, the contracts will address confidentiality provisions. So kind of the starting off point is that nobody is to share identifying information about the involved parties, about the terms of the agreement, or anything relating to the child with any third parties or any kind of social media unless otherwise agreed to by the other parties involved. So that's kind of like the standard language to make sure that things are not shared unless agreed to. Obviously the parties will need to discuss some certain parts of the agreement with your fertility clinic and the hospital. So that's typically carved out, as anything in connection with the agreement would be discussed, but amongst third parties, things are to remain confidential. So parties do need to be aware when they're entering into some kind of third party arrangement that they're aware of the contractual obligations regarding confidentiality. So things are not shared just even inadvertently or innocently on social media. For example, just a simple picture of an ultrasound could possibly share identifying information about the surrogate, even though a parent may be so excited just to share with the world that they have a confirmed pregnancy. Everybody has to be really careful about not sharing anything identifying unless, of course, the parties are okay. And sometimes that consent to share with everybody would need to be in writing. So talk to your attorney about making sure that confidentiality is properly addressed within your agreement. And if you have any questions as you proceed with your journey on what can and can't be shared, you can clarify that within your agreement or with your attorney as well. If you have any questions regarding confidentiality within third-party reproductive matters, within donation matters, or surrogacy, please feel free to contact me. My phone number is 954-761-2929. Just one more thing to mention, since we're talking about confidentiality, within the surrogacy statute within Florida, everything is actually handled very privately when we do actually submit your documents to the court to confirm the parental rights and ultimately get the birth certificate. So the court docket in Florida is sealed. It's not a public record, so that actually adds a level of privacy to the matter, that the people cannot easily just search what's going on within the court document. The court docket. The courtroom is emptied out when the matter proceeds in front of the judge. So that does give a level of comfort to the parties involved that this is as private as it possibly can be within the legal system as far as the parties' rights and kind of knowing the identity of everybody involved. So again, my phone number 954-761-2929, and I look forward to hearing from you. Thank you.